Right, court is calling 2021 CR 9284, State of Texas versus Elizabeth Yepes. Can I have parties announced for the record for the state?
Ryan Groomer for the state of Texas.
For the
Robert
defendant?
Maurer for defendant.
And are you Ms. Yepes?
Yes, sir.
Ms. Yepes, I'm showing you what's entitled application for community supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, sir.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Yepes, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We're not, Judge. There's 2 counts on there, Judge. We proceed on count 2, and we would waive the enhancement allegations. We would also waive count 1. Count 2 is a second-degree felony, straight possession, 4 to 200 grams.
Any objection?
No, Your Honor.
Ms. Yepes, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Did you understand the state is proceeding on count 2? And that charge is possession of controlled substance filling group 1, 4 grams to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
If you have. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. All right, so we're going to come back on July 25th at 9 a.m. for sentencing. Ms. Yepes, the court will make its decision on your application based upon a report I received from probation and any other evidence that's presented to me on that date. Do you understand?
Yes, sir.
Mr. Maurer, is there a need for a TAP evaluation?
I'd ask them to be done, Judge.
And Rebecca, there's going to be a TAP evaluation.
Yes, ma'am.
All right, the probation officer is here and back. She'll go over everything that needs to be done, but do not leave before you get a reset form.
Yes, sir.
All right, if there's nothing else.
Not on this case, Judge. I would like to approach another case.
All right, thank you. Back in the afternoon. The court is calling 2021 CR 9284, State of Texas versus Elizabeth Yepes. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Robert Maurer for defendant, Your Honor.
Are you Ms. Yepes? All right, you entered a plea on May 9th to count 2. You entered a plea of no contest. The state waived the enhancement and count 1 without objection. According to the plea bargain agreement, punishment is to be assessed at 6 years in the prison. There's a $1,500 fine and the state opposes your application. Have both parties had a chance to review the PSI report, state?
Judge, not yet, but I'm working on it.
Judge, I've reviewed the PSI. It's pretty straightforward. The state was opposed based upon, I think, the prior criminal history. and the amount of drugs.
All right, so are both parties ready to proceed, state,
I'm ready.
defense? All right, state, you are opposed.
Yes, Judge, we are.
Do you have any witnesses?
No, Judge.
All right, defense, do you have any witnesses?
Judge, no, I'm just arguing on behalf of my client.
All right, the court will hear argument, state.
Judge, that's correct what defense counsel said. Our opposition is based mainly on this defendant's criminal history. Looking at the PSI, it looks like she's been given a chance at probation at least twice before. It looks like in 2005, she was granted probation for 10 years on a felon in possession. And she ended up being revoked. And actually in 1993, she was given deferred and then placed on probation and got revoked. So that's.
Well, thank goodness someone in that courtroom still remembers what the law actually is. While the defendant fumbled through "yes, sir," like they were ordering fast food, and the defense tried to spin a felony possession charge like it was a minor parking ticket, the judge calmly reminded everyone that no contest doesn't mean no consequences. With the patience of a saint and the precision of a sledgehammer, they sliced through the courtroom chaos, laid down the law, and somehow managed not to roll their eyes while explaining, for what was surely the 100th time, that probation isn't just a vibe, it's a legal structure.
Twice that she's been given a chance. It looks like we played the offense down just to give her a little bit of benefit for accepting responsibility for her actions. But that's why we don't believe probation would be appropriate in this case. And we're asking for prison sentence.
All right, defense.
Judge, we understand fully why the state made the recommendation they did. Ms. Yep has asked me to speak on her behalf because I think she's kind of nervous speaking in public. Since her release on this case, Ms. Yep I think, has made significant strides in turning her life around. She finally got a job at Mood Solutions. She's been made a supervisor. She makes $15 an hour. I think this is probably the best job and the best situation she's found herself in. I guess for a number of years, I think she's really got her situation solidified, and I think she would benefit from the opportunity for probation with whatever terms of what was appropriate. That's obviously the most important thing. I would like the court to consider that and consider one, I think her remorse of finding herself in the same situation again. I think TAP talks about issues that have been on again, off again with drugs in her life. You would ask the court, if the court does see fit to give her probation, to allow her to do intensive outpatient. She's very concerned about keeping this job that she was finally able to get. I think it's very difficult for people with Elizabeth's criminal history to find jobs in the workforce. And I think this company is willing to work with her. And I think it's put her in a situation where she can be a successful part of society. So that's the court to grant that.
All right, so the court has a question because it says on here, guilt minimized.
I think they were talking about on her, when I look at that, when I read that, I think they were on the TAP evaluation, they were talking about her drug usage.
Okay, all right, Ms. Yepes, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Did you commit this offense? All right, so I want to talk to you about your criminal history because that is concerning. I always tell people the criminal history is sort of like a credit report, but it's a credit report related to whether or not I should give you probation. You understand? So your misdemeanor cases, this theft, you were sentenced to 32 days in jail. And I understand how that happens. People just want to get their judgment satisfied and be done. The same thing with hindering apprehension. Then we have the assault, bodily injury, family household, 90 days, theft, 44 days, possession case, 20 days, another possession case, 20 days, then failure to ID, 1 year. So this is what's concerning to me. You pick up a felony in 1992 and you were granted deferred adjudication and you didn't complete it. Why didn't you complete it?
It's very young. My husband was very abusive and I didn't do what I was supposed to do. I didn't go to class.
All right. November 2005, felon in possession of a firearm.
That was at my house when they came looking for my son. My house, it was my husband's house. I was charged with that.
All right. Then we have December, the drugs, 4 to 200 grams.
But he was a,
You don't remember, just tell me.
remember,
All right. So then we have 2007. You were sentenced to prison and then you had a parole violation. It appears that you're not learning anything from your prison. Then we have 2014. So 2014 prison.
Because clearly, completing things just wasn't her strong suit. Probation in 92, fumbled. Another shot in 2005, fumbled again. It's like the justice system handed her the ball twice, and she ran it in the opposite direction both times. And yet, here we are again, asking the court to toss her another Hail Mary, like the third time's the charm. Honestly, the judge deserves a gold medal in patience just for reading that criminal history out loud without bursting into laughter or tears. The courtroom isn't a free trial subscription you cancel once it gets real.
And paroled to a felon in possession. I'm assuming these cases were ran concurrently. And now we're here. So I don't understand. I don't know if there's anything that I can do for you because you have not learned anything.
Since last time, I've learned a lot. I haven't worked in my life like that. I've worked now. I've been working for almost 3 years now. I was given a chance to get a position as a supervisor's responsibilities that I have to do. Something I haven't done in many years, so it's yes. I feel like I've worked for it and I want to continue to keep it. If I lose it all, then I feel like I can age and that with my history, my background, which is not ever going to change. I won't be able to, I won't make the lifetime.
And here's, I'm sympathetic to what you're telling me. I'm sympathetic to you getting your life in order, maybe finally. But here's the problem. The amount of drugs was a lot. And your history is awful. All right. This is what I'm going to do. I'm going to find her guilty as previously stated. I'm going to sentence you to 4 years in the prison. Give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I call it your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? All right, and we're off the record. Ms. Yepes, I actually gave you less than what you bargained for because I did consider the fact that you did come in with employment. You understand? Do not come out and do this again because you don't know who your attorney is going to be. You don't know who the prosecutor is going to be or who the judge is going to be. And you will be a habitual and your minimum will be 25 years in prison. You understand? All right, good luck to you.
Thank you, Judge.
You're welcome.
And I
Jose
think
Munoz.
That's my case, Judge.
And there it is, the judge giving out mercy like it's Black Friday, even when the rap sheet reads like a criminal resume. Seriously, this defendant's record was practically begging for a prison tour package, yet the judge still shaved down the sentence out of pure grace and maybe disbelief. After multiple chances, revoked probations, parole violations, drug charges heavier than a gym dumbbell set, this courtroom moment was less about the law and more about a masterclass in restraint. The judge could have thrown the book so hard it left an imprint, but instead delivered a warning with a side of wisdom. One more mess up, and it's a 25-year farewell tour.